Number 191, Stonehill Capital Management versus Bank of the West and Mission Capital Advisors. Counsel?
Good afternoon.
Good afternoon.
May I have 4 minutes of rebuttal time,
Yes,
please?
you may, sir.
Martin Eisenberg, attorney for the appellant Stonehill Capital. The hallmark of an auction is the formation of a binding agreement upon the seller's acceptance of the purchaser's winning bid. And where the material terms
Were you
of that-
still negotiating the terms when you were going back and forth with the LSTA and the LSA?
No, Your Honor.
No? Okay.
We're not negotiating the terms. The bank had agreed to use the LSTA document as the purchase and sale agreement, and...
Where is that agreement in?
I beg your pardon?
Where is that agreement? And counsel's emailed to you that there was a preference for that particular form?
Correct. There was a preference for that particular form, correct. And then the form was sent over to counsel for the bank, and counsel for the bank did not make one contemporaneous communication that it had any disagreement with any term.
But they didn't sign it, right? They didn't say, "We agree." Did they ever send anything that said, "We agree to these terms"?
They agree, the entire concept of the auction was for the terms to be pre-negotiated. And so the whole purpose of pre-negotiating the terms of sale through a pre-negotiated purchase and sale agreement was to establish the material terms of the sale so that when the acceptance was given, the material terms were set and the contract became a binding contract.
If we assume for the moment that there's some ambiguity in the language that's subject to, and that we're looking for intent based on words and actions, what is it that indicates that intent?
Well, there's words. Well, let's start with the words, and then we'll go to the actions. As far as the words are concerned, none of the words that the bank used are legally sufficient to manifest an express intent not to be bound absent a signed agreement. And all of the cases hold that. The subject to language in the acceptance is legally insufficient. The language regarding merger clauses in a proposed agreement is insufficient. Withdrawal of the asset at any time is insufficient because this is an auction sale. Any time can't possibly mean any time. So there has to be a cutoff as to when any time ends.
And that's when the gavel falls, or?
It's when the gavel falls.
Yeah, I am a little confused by that because I thought that Stonehill was the one who originally objected to the proposed sales agreement subsequent to the auction. I thought that on Monday, April 23rd, 2012, Stonehill's counsel was the one who originally objected and sent them a red line that were changes that were fairly substantial.
Respectfully, I
Disagree.
we disagree.
Yeah. Sorry.
The original loan sale agreement that was sent over by the bank, which was supposed to be the pre-negotiated purchase and sale agreement, was insufficient to transfer this was a syndicated loan.
Okay.
What the bank sent over was a loan transfer agreement for a bilateral loan. So at that point, Stonehill said, "You've got the wrong agreement. What would you like us to do? Would you like us to modify this agreement to make it applicable to a syndicated loan? Or would you like to use the standard Loan Syndication and Trading Association form that everybody uses? Which would you prefer?" After Stonehill made those communications, the bank accepted the bid, and a few hours after the acceptance of the bid, the bank's attorney said, "We prefer to use the loan sale agreement by the Loan Syndication and Trading Association." So Stonehill didn't reject any agreements. In fact, the agreement that was agreed to by the parties was the very loan sale agreement that the bank requested. All Stonehill did was send them the very agreement that the bank requested. And after Stonehill sent that agreement to the bank did not indicate any disagreement with that form.
What about subject to mutual execution of an acceptable loan sale agreement?
Yes.
That's the email on the 27th.
Yes, that language, subject to the mutual execution of a loan sale agreement, is insufficient to create an express condition that they would not be bound unless and until.
And you're saying that's because there was a prior agreement to the form?
Well, here's what I say.
Okay.
I say when they accepted the bid, subject to a mutual execution of a loan sale agreement. Firstly, the bank had an obligation to negotiate in good faith to reach that loan sale agreement. Because under IDT versus Tyco, where you have an agreement which is conditioned upon a further agreement, the parties are obligated in good faith to negotiate to reach that further agreement. So the bank sets forth auction terms which state pre-negotiated agreement. They then accept the bid and say, okay, accept the bid subject to negotiating the agreement. At the first instance, that imposes an obligation on both parties under ITT to negotiate in good faith to reach an acceptable
So
agreement.
is that your alternative argument?
Correct.
Or is yeah, because your original, I thought your initial argument is that there is an agreement as soon as the bank accepts Stonehill's highest bid. That's the contract right there.
Correct. That's my fallback.
Because, okay, I
Yeah,
just wanted to be
that's
clear
my
about
fallback.
that.
And then when.
Yeah, but if I understand that that's your fallback, if I
Yes.
just want to clarify this point.
Sure.
That's a fallback because you say the actual agreement was pre-negotiated. right?
Correct.
Because the offering memo says there's a pre-negotiated agreement. You were aware of what it was.
Right.
You knew that. When you send in your bid, you understand that. But you have informed them, look, it looks to me like you're using the wrong form. So it sounds to me like you're arguing, we understood the terms, we agreed to those terms when they accepted our bid, we all accepted the terms, and this is about swapping out the forms with some technical changes back and forth.
That's correct, Your Honor. That's our position. So, and of course, the bank's newfound disputes with the loan sale agreement after they get sued are completely, not only are they disingenuous, but they're irrelevant because under Brown, it's the subjective intentions of the parties at the time that they enter into the transaction that governs, not disputes that they contrive retroactively to make them nunc-pro-tunc to the time that the agreement was.
What would happen when you, let me ask you this. You say they didn't respond when you sent them the proper form with whatever modifications. If they hadn't come back and disagreed with any of those, what happens then? Is there a breach on their side? What would that constitute?
Well, if they come back and they say, well, we disagree with something, first of all, I don't think they had the right to do that because they agreed to the pre-negotiated form. I don't think they had the right to mandate auction terms that said that the loan sale agreement is pre-negotiated, get the form that they request, and then say, okay, by the way, we want to pre-negotiated. I think they were.
I'm sorry, had you sent them what you're saying is the pre-negotiated form before they accepted, before the April 27th email?
They accepted the bid.
Yes.
A few hours after they accepted the bid, they said, we want to use the Loan Syndication and Trading Association form.
That's what you're saying is the email from the bank's counsel saying,
Correct.
I prefer it too.
Stonehill didn't prefer it. The bank, it's the.
No, I understand,
Yeah,
but
I'm sorry.
yes. But
Yeah.
you're saying it's the bank counsel's email saying, I prefer that form also.
Correct. It's that, so there you have the acceptance, and then you have the agreement to use the pre-negotiated purchase and sale agreement.
Thank you,
I
counsel.
think my time is up. Sorry.
Counsel? Good afternoon, sir.
Good afternoon. May it please the court, I'm David Critchlow from Cadmucheon on behalf
Mr.
of
Critchlow, if the
respondents.
pre-negotiated sale agreement had been the proper document, would there have been a contract under these circumstances?
No, because what is surprising to me as respondent and what is belied by the record is, on the one hand, counsel for the appellant states something accurately, that it was supposed to be a pre-negotiated contract. Those who were purchasing pursuant to the auction terms knew it, and in exchange for getting a pool of distressed assets at 27 cents on the dollar, they had to give a 10% deposit. They had to execute the pre-negotiated, pre-arranged agreement. What is undisputed is that is not what happened. Immediately, that loan sale agreement was sent back marked up. And if you look at the record, there is an email exchange where it is indicated by Stonehill that they intend to make minor technical changes just because it's a syndicated loan.
But didn't they tell you at the time that they put in their bid that the form that Mission had circulated and made available was not the proper form for this type of transaction?
I don't want to misstate the record because the timing is a little tricky.
Okay.
It's around the same time. I
But
don't
it's,
know whether it
let
was
me make it
before.
easier. Is they did that before the bank accepted the bid, isn't that correct?
I believe they did, but after.
So why is the bank accepting if they're already telling you it's the wrong form? This is not the form that's used for this kind of transaction.
Well, pursuant to the auction criteria, the bank is obligated by the offering memorandum to accept the highest bid. It's a conditional auction, however, and it's been made
Does that
clear.
mean, I don't mean to interrupt you, but
Sure.
does that mean that if the plaintiff in this case had said, you know what, we overbid, and so we're going to call them up and say, you know, we didn't want, instead of 2.3, we really want to give you 1.9. Could you make them give you the 2.3?
That's an interesting question.
I think
That's-
you can,
that's-
is my point.
that-
It
that-
seems
that-
to me, either that, or we
Right.
don't understand the industry. And
Right.
one of the things that's in the back of my mind is, maybe we don't understand the industry.
No, I think you do understand it, and the reason I hesitate only is because that issue's not before the court, but I
Well, it's
think
not,
the
but
answer is
see,
yes.
Let me give you my
Sure.
full thought. You're saying, even though they said, you know, we're going to give you this money, and you're fighting over what seems to me to be a ministerial act of whether it's a quitclaim deed or a full covenant deed, so to speak, on real property terms. In other words, the form is consequential, but not, the deal has been made.
No, I would disagree with you, but
Right,
continue.
you're going to disagree with me,
Yes.
because otherwise, if I said, you know, they instead of 2.3 said, you know, it's 1.9, you'd say, oh, okay, then the bid is off, and everybody that bid is out of luck, and we're just gonna lick our wounds and take this loan back.
Well, it's an interesting point. It's one of the reasons why the offering memoranda and offering memoranda like this in the auction industry throughout the country reserves the same right that my client did, which
But
is
I
to
looked
take
at
away
that
the
right
asset.
as being up to the point of the sale. In other
Up
words,
to the point of a consummated sale
up
pursuant to the
point-
terms.
Up to the, a better way of saying it, but up to
Yes.
the point when the gavel falls, because now they're stuck. They better come up with the money or you're going to sue them, and you're going to give them the loan, which they then can renegotiate, which obviously they later did, renegotiate with the debtor, right?
Right, and now where I want to come back to an area where you and I disagree is it's not just ministerial terms. An agreement on forms is not an agreement on terms.
Could you have signed the LSA as you proposed it to them?
Would my client have?
Yes,
Yes, they would have. I don't think the question is.
but it would have been the wrong form.
No, well, not necessarily. There's.
But you
You
didn't
could
your
have done.
counsel agree that it was the wrong form?
No, he agreed that he preferred, I want to be very, very precise on this. He agreed that in syndicated loan transactions, he too preferred to use the LSTA agreement. The LSTA agreement is like an ISDA agreement or like a general.
So your counsel was operating outside of the instructions of his client.
At that point, I can't tell you what the instructions were. I think he was giving advice that, from his perspective, if the terms using the LSTA form had remained the same, would not have made a difference.
But when he got that form, he didn't reject it. He didn't say, what are you doing here? We're not going based on this form. We want you to sign the LSA.
And nor does he have an obligation under New York law, because what they did do, and what was clear in both the LSA and in correspondence from the auction administrator, is there were terms to the agreement. The parties intended not to be bound unless there was a written and executed
Well,
agreement. There's no obligation for my client to do anything, to negotiate in good faith, or do anything. The offer
But
was
that's a good
rejected.
point. This
Okay.
rests on what, you just said, it was the party's intention. That is the question here, is it not? What was the party's intention? You may feel that
Sure.
you may feel that as a matter of law, it shows that it's your client's intention, but that is the question. And isn't that usually a question of fact? And isn't that what we're talking about here? As you say one thing, they say another?
Well, not here. And if you look at Scheck, which is instructive and has been followed, it is this court's decision, it has been followed for over almost 50 years. Scheck takes situations like this and says, when the parties clearly evidence their intent through the contracts themselves, through the drafts, to be bound only by a written agreement. And the interesting thing is, Your Honor, I want you to understand.
But that's
this-
the question, is does this language express that intent clearly and unambiguously.
Not only does the language in the agreements promoted by my client, but if you look at the language in the drafts that are submitted by Stonehill, that's where I think the appellants suffer, because they indicate an agreement not to be bound unless in writing.
Mr.
Yes.
Kuyama, am I pronouncing that correctly?
Kuyama?
Kuyama?
Yes.
In his April 27th email, said preferred to use the LSATA documentation to transfer the loan and would forward such documentation next week. Then a week later, he advised counsel he was working on getting him the documents.
Correct.
Sounds like he likes the LSTA.
As a form. Now, I want to make it clear, my argument is an agreement on form is not an agreement on terms. You can use the LSTA the same way you can use any short
So
form
what was the
agreement.
different term? That's what I'm trying to figure out.
Okay.
What was the
Well,
different
if you
term?
think back on the record, one of the first things that Missions Counsel said when they received a markup is it's heavier than we thought, and then there was a 3-page explanation that acknowledged that they were not minor changes, but major. They refused to agree to indemnification protections that my client insisted upon in the sale. And they added an indemnification obligation to my client, which was not part of the offer. At that point, the offer is rejected. That's a material term. They took a non-refundable deposit, and if you look at, and I can give you the record site here in a second, the definitional change on record page 189, when they changed the definition of deposit, they change it from a non-refundable deposit to a fully refundable deposit, and with the right to get out of giving the deposit and make it clear that that deposit will not be given, as opposed to being a condition precedent to the sale, until after their form and their terms
So
are
you're
agreed
saying,
to and
counsel,
fully executed.
You're
I'm sorry.
saying that this sale would not have gone through even if your client had not discovered that they were losing $1,800,000 or thereabouts by accepting this offer?
Well, absolutely not on the terms, and that was made clear when you see the correspondence from Mission, which was the auctioneer administrator, that said, in essence, and I'm paraphrasing now with colloquialisms, whoa, wait a minute, that's a lot bigger than I thought. I'm not sure the lawyers will agree to this.
I'm sorry, what's the date of that?
That's upon receipt of the first markup of the LSA. So forgive me 1 second. I believe that's April 23rd.
Thank you, counsel.
Thank you.
Counsel? Yep, hold on 1 second, sir.
Oh, I
You're
forgot.
jumping the line.
Good afternoon, Your Honors.
Good afternoon.
May it please the Court. My name is Damian Cavallari of the law firm Hoge, Newman, Regal, and Kenny, representing Respondent Mission Capital Advisors. So the issue before the Court, as Mr. Critchlow has explained, is whether Bank of the West properly withdrew its loan prior to Stonehill meeting the conditions that Mission set forth in the offering memorandum that was put into publication in March of 2012. The Appellate Division said yes, and this Court should say the same respectfully, for 3 reasons. First, Mission throughout the auction process made clear that it was Bank of the West's intention to only be bound by definitive executed statements. This was in the offering memorandum, and it was also included in the language in which Mission provided the confirmation email to Stonehill saying that it would be subject to the execution of a mutually agreed upon loan sale
So
agreement.
you said that the appellate division agreed that there were conditions preceding to the formation of the contract, but I don't recall the appellate division addressing that issue at all.
Your Honor, the Appellate Division held that while the auction was a conditional auction, this means that there were certain conditions post the close of the auction that were required to complete the loan sale. Those conditions
So
were...
you're saying that they could have pulled out, as I asked Mr. Critchley, they could have said, yeah, we bid 2.3, we changed our mind, we're not doing it.
Well, actually, here, the way the conditions were laid out was that it was on Stonehill to sign and provide a
So it's a
deposit.
yes, they could have said, we bid 2.3, our mistake, never mind, bad bid.
Yeah, yes, Stonehill could have done that, much to the detriment of their status in the market. The question...
Well, I mean, you mean people would frown on them?
Yes, I believe that the way Mission conducts their auctions is
Suppose you had somebody who offered a debt and agreed to a sale, and then realize that the person who bought the debt is going to get a better deal than they do, and they decide to revoke their consent to that sale, would that hurt them in the industry?
You're talking about, I just want to make clear, I understand, Your Honor. You're talking about the buyer or the seller in this case?
I'm talking about the seller.
The seller here had already provided their agreement to the buyer. The buyer need only sign the proposed agreement, the pre-negotiated agreement that they were provided
Mr.
with.
Critchlow just said there's no difference between the two. I mean, it could have signed either one, and I mispronounced the gentleman's name, but he said that's a better thing. Let's go with the LSTA.
Well, the LSTA was merely a starting point for the rest of the agreement. The LSTA is a form that you can then amend.
I don't find that in the record. I read all these emails, and finally, when they said we're not going through with this, that we have the right to do this. They didn't say we don't like that you invented an indemnification. They don't say anything other than we've decided that we're not going to sign this. Why? Because you're making $1.8 million that we wish we had made. I thought.
Well, Judge Pickett, this was the first time that Mission had ever encountered an LSTA form. This is not something that is universally used through Mission's auction practice. Second.
Is that because you're not familiar with this type of bidding? Because LSTA and their amicus said this is standard in the industry, right?
Right. Well, the LSTA, and the reason why we had to submit a separate brief is that they were just incorrect in the way that Mission conducts their auctions. Mission conducts auctions using these pre-negotiated loan sale agreements, not LSTA forms.
The counsel for the bank says, I prefer it too, and I've used these in the past. And oh, I didn't even realize it was that kind of a transaction. I was misled.
Right, and then what you'll see further down the line is that there is a marked-up version of the LSTA form. I believe there's an email.
Let me ask you a different question. If instead of Stonehill coming forward and saying, that's the wrong form for this kind of transaction, if indeed, after accepting the bid, the bank had said, oops, we realize it is the wrong, without Stonehill even raising this, it's the wrong form, and we need to use the correct form. Could Stonehill have said, that's not what I bought into? Could Stonehill have then pulled out of this arrangement?
Well, Stonehill would have to sign the form that was proposed because that was part of the conditional auction.
That's what I'm saying. So the bank could, you're saying that nobody could change this form, even if the bank itself had realized that's not the proper form.
Well, if
They
it
were
was-
bound to only sign that original form that was circulated
Well,
by Mission during this memo offering process, correct? Is
Well, I
that-
just want to make sure I understand, Your Honor. So first, you're saying that if Stonehill would have just signed the incorrect version, I see my time is running, may I
Please.
complete
Please.
my answer? So so I understand your question is, if Stonehill had just signed the pre-negotiated loan sale agreement that Bank of the West had proposed as part of the agreement and provided the 10% deposit, could they have completed the loan sale? Technically, based on the terms of the offering memorandum, they could have, but they did not here. They continued to negotiate the agreement, and they utilized their position as the
Well, I had
buyer.
actually asked something slightly different, so if I can go back to my original hypothetical, which was before they sign it, the bank realizes the wrong form. Is Stonehill still bound to this arrangement, to actually buy this loan?
So
If the bank comes back and says, listen, it was the wrong form, this is the form we're going to use.
and they provide the form for Stonehill to sign.
Correct, and Stonehill says, that's not what I agreed to. I was willing to sign the other form. I don't know about this form.
And then the parties continue to negotiate the terms of that form that
Let's
they're
just
going to
stop,
sign.
no, let's just end there, forget the further negotiation. Can Stonehill pull out at that point, because it's not the form that they had originally seen before they bid?
I believe so, Your Honor. They would have to sign the form because all of this was contingent on a mutually executed loan sale agreement.
Thank you, counsel.
Thank you.
Mr. Eisenberg, what about Mr. Critchlow's argument that not only was the form changed, but the material terms were changed as well?
I think my colleague is conflating forms. The first form that was sent over by Stonehill was the modified form because the bank had sent over the wrong form. When the bank realized it was the wrong form, the bank picked the form, not Stonehill. So he's just trying to disown his own document. The indemnification clauses, the material terms, those were picked by the bank. It was the bank that said, we would like to use this form. Well, now that $1.8 million came in on a refinance, now they say, you know what, not a good form. We don't like it.
I'm sorry,
Counsel,
when
can
did the
you-
bank
I'm sorry,
say-
can you explain to me the refinancing? How does that happen? I mean, it seems like that's a Stonehill entity that does the refinancing here?
Correct. This was not any issue that was discussed below, but I will tell you exactly what
Please.
happened here. The bank entered into this is a syndicated loan, and there was a forbearance agreement entered into by the lenders and the bank, under which the lenders agreed not to foreclose on the loan, because it was in default, to give the borrower an opportunity to refinance, hopefully for $90 million. So nobody was going to foreclose on the loan. During the time that the borrowers were trying to obtain their refinancing, it's important to note that the bank put the loan up for sale. The bank put the loan up at the auction knowing that the loan could be refinanced. So there's no surprise when it turns out that the loan is going to be refinanced. So the fact that the refinancing came from Stonehill or from any other third party really doesn't matter, because it's no surprise to the bank that the loan could be refinanced during the auction period, because they knew about it at the time the auction
And
was
forgive
put
this
up.
basic question, but would you have, your affiliate, would Stonehill have refinanced if they didn't think they were getting this loan?
My sense is Stonehill was already a lender in the facility.
Okay.
My sense is they didn't specifically commit to a $150 million refinancing of the entire syndicated loan so that it could
Right.
make money on this particular transaction. So
So it was a commitment for the entire,
it was a commitment for the entire syndicated
understood,
loan.
thank you.
Can I go back? You said that the bank sent its own forms. When did it do that?
I beg your pardon?
Well, you
Your
said the bank responded with its own form.
Honor? Right.
When did they do that?
When they agreed to use, they said, we'd like to use the LSTA documents, and we'll send them over. Okay, so we were waiting, Stonehill was waiting for the forms, and the bank said, I'll get it to you by Monday.
Right.
And then they weren't coming up with
While
the
that was
forms.
going on, counsel, could you have pulled out of this arrangement?
No. No, the bid was accepted, the pre-negotiated agreement was accepted, the parties were bound. This was an auction. It's not an option. The bank is trying to treat this as a one-way option, and that's just not right. And I think one of the most telling indications that the bank recognized that the acceptance of the bid would bind them is the sale, is there's a memorandum from a bank, executive of the bank that says to his counsel, we need to get comfortable with the proposed loan sale agreement prior to the acceptance of the bid. Okay? So if the bank believed that it had no obligation unless and until that loan sale agreement was signed, why did it need to get comfortable with the loan sale agreement prior to the acceptance of the bid? The reason why it needed to get comfortable prior to the acceptance of the bid is because it recognized that once the bid was accepted, it was bound to sell the loan. I see my time's up.
Thank you, sir.
Thank you, Ron.